Hi, this is Jill Murphy from Pharmacy Times. Before we get started today, one of our top stories on Pharmacy Times is about how a new diagnostic test for heart failure could help COVID-19 patients. Today I'm speaking with Ron Lanton, principal at Lanton Law, about Rutledge versus PCMA and its impact on pharmacy and PBMs. How are you doing, Ron?
I'm doing good. Thanks for having me today.
Thank you so much for joining me. So my first question is, at its core, what is the issue being discussed in Rutledge versus PCMA?
Well, Jill, I think there are two issues at play here. The first is the official issue, and then the second is kind of an observation that I have. So let's talk about the official issue. And this actually comes from the Supreme Court. So if we're wondering, usually when you're before a Supreme Court and you're looking at the caseload and you're trying to find a specific case, they have like an outline or just brief an outline of what they're talking about. So let me just read you what the official outline is. It says whether the U.S. The question in this case is whether the U.S. Court of Appeals for the Eighth Circuit erred in holding that the Arkansas law that regulated PBMs, otherwise known as pharmacy benefit managers, drug reimbursement rates, which is similar to laws enacted by a majority of the states, is preempted by ERISA, otherwise known as the Employee Retirement Income Security Act of 1974, in contravention of the Supreme Court's precedent that ERISA does not preempt rate regulation. So in English, basically, does this Arkansas law, is Arkansas preempted by federal law in regulating PBMs? Okay, so that's the official reason that we're here. I think the real reason kind of comes out of that official where the PBMs have been very aggressive the last several years in trying to make policy and to force change on pharmacies, which had been to the pharmacy's detriment as far as reimbursement goes. So the question here is whether a PBM can operate with hardly any oversight. We know they don't have any federal oversight and hardly state oversight, depending on what state we're talking about. So can they essentially run as an insurance company without being regulated as an insurance company? So those are the two issues that I think that we're talking about at issue here.
And with that being said, how did we get to this point? Like, can you give us a top level overview of the case?
I can gladly. So it's interesting to me because I do a lot of state legislation against PBMs, on the state level, and I've seen a lot of different arguments they've made. Over the years, they've made arguments that any oversight is against the contract clause in the Constitution. I've seen that. This ERISA thing kind of started being in play right around 2013, 2014-ish. The reason why I believe that is we were at that point in time under passing more laws in states when it came to maximum allowable cost transparency, audit protections, things like that. So what we started to notice from our clients was that this DIR issue started coming up into contracts. And that was kind of a weird area at the time because it's part federal, part state. So at that time, we didn't really have a good strategy for that yet. They started getting a lot more aggressive right around 2015, they being the pharmacy benefit manager. So they were losing a lot of policy arguments in the legislature because I think the legislature started to understand that, wait a minute, not only do we have an entity that's not regulated, but they're really not playing fairly by the market rules. They're picking a lot of winners and losers, who's in the network, things like that. So the first case that we noticed in Iowa, PCMA versus Gerhardt. This was a case, it was, again, Iowa was actually trying to pass some pharmacy benefit manager regulation. And they started to raise, for the first time, this ERISA exemption that we really shouldn't have any state oversight because it infringes on our ERISA protection, the self-funded plans. So that was the first time where they started making this. Then in 2015, same year, they did the PCMA versus Rutledge case, which is what we're going to talk about a little bit further detail. 2017, they had PCMA versus Tuft, and that was because of North Dakota. So North Dakota had two bills at the time. Basically, what these two bills did was they addressed gag orders, clawbacks, PBM transparency, accreditation standards, things like that. And they raised the same argument. This is really against ERISA, right? So we're like, okay, we notice a pattern. And just recently in 2019, and we got some a ruling on this from the district court, kind of a ruling, but not a full one, where they went after Oklahoma's law. It's now PCMA versus Mulready. Again, this was filed in 2019. Again, they said that this Oklahoma law, where they were really trying to get patients the right of choice in order to have an open pharmacy network, to go and choose what they wanted, That was against ERISA, so big surprise. So really, this case, this PCMA versus Rutledge, is the first time where we're really trying to put some foul lines in play here about who can and who can't do things. And is this a real issue, which we don't think it is. And like I said, we can go more into detail about why I think that way.
Exactly. And my next question actually would be, how will this affect pharmacy? Like, what are the implications of this case exactly?
So again, this is one of those things where they've raised this argument. We've seen similar arguments in the Supreme Court where it comes to insurers and not exactly pharmacists. We saw in 2003, there was a Kentucky versus Miller case, a different provider, I believe it was a chiropractor. And they were fighting open networks. You know, the chiropractor wanted to be in an open network. The insurers didn't really want that. And they were saying, yeah, it's really against ERISA. Well, they had a Supreme Court opinion that was written, I believe it was by Justice Scalia. And he was basically saying, you know, this is a really narrow scope that you guys view as a PBM or insurers are really trying to argue here. And that's really not what the law says. So I know that we've had some other cases that have been right there. And what's interesting about, you know, and I hate to pick on the PBMs, but, you know, for pharmacy time, they'll do it. But basically, you know, what's interesting about these guys, they're very smart lawyers. And, you know, lawyers, we look at, you know, I'm a lawyer, you know, we look at the ins and outs and we try to find the technicality and we argue on that, you know, and no matter how narrow it is. So they're doing their job and trying to find out, you know, how narrow this is. But I think once we understand what this ERISA game plan is, at least get this final decision by the court, I actually feel pretty good about it. We have the Solicitor General that weighed in. And what was interesting, the court sometimes asks the Solicitor General what they think on certain cases. In this case, it was called a CVSG, a call for the views of Solicitor General. So they wanted to say, you know, what do you think? And at the time, Solicitor General Francisco, I know he's just left here recently, so I kind of got confused because I know there hasn't been a new Solicitor General yet. But at the time, he said, look, you know, the Eighth Circuit, we believe, is wrong, and Arkansas didn't really reference an ERISA plan or have an impermissible connection to this. So if you look at his letter in totality, you'll see he doesn't agree with the PBMs. And I think anytime that you have a Solicitor General that doesn't agree with the PBMs and you're going into a case about a PBM, doesn't really bode well. So hopefully I'm not mistaken, but I'd be truly surprised if we get a ruling in their favor. And I think that would really open the floodgates for pharmacists, because every time we pass a law for pharmacy, we have to kind of look over our shoulder and wonder whether A, it's going to get challenged by litigation because of this aggressive stance I told you about that started in 2015. But B, you know, what's their next argument? And that's been their consistent argument since 2015 is, you know, we're exempt from ERISA. So having that barrier removed, I think we could start addressing things like DIR. States can feel more comfortable about going further and regulating, especially with the Bureau of Insurance, because a lot of Department of Insurance commissioners have been hesitant until there's been like a real major case to say, okay, this is how we're going to regulate these guys.
Definitely. And like you said, several states are attempting to move forward with legislation, which limiting the influence of PBMs. I know Georgia and Kentucky are some of these states. Can you speak a little about those issues and what states are trying to do right now?
Definitely. States in general have been, you know, plugging holes. So there's been a lot of holes with audits. There's been a lot of holes with transparency, things like that. So you see variations of that. And some states have just had to go back, even though they've passed an audit law. I know this from personal experience. And they being the pharmacy benefit manager, will try to find a way where that doesn't apply, and they'll argue, so you have to go back and pass another law to make sure that that happens. When it comes to Georgia, they passed two laws this year, which were interesting. One is called the Pharmacy Anti-Steering and Transparency Act. This act sought to prohibit PBM and payer-owned pharmacies from filling prescriptions that were received from prohibited referrals from their PBM and insurer affiliates. So it's more like the steering that we're starting to see, where a lot of patients were getting confusing letters from the PBM, and they were saying, well, you can't go to Joe's Independent Pharmacy anymore, you have to come to ours. And they would, you know, whenever we would call attention to that type of behavior that should not be happening to a Department of Insurance, they would say, well, that's not really what the letter says. When that's, you know, so they kind of got busted. So the other thing that they passed this year was HB 323. This actually restricted a PBM and insurer patient from steering. strengthened the anti-mandatory mail order provisions, and actually added a lot of additional protections for audits, and stopped the mining of patient data. So it stopped that allowance of the steering that was going on. The other trend that we're seeing, and I'll talk about Kentucky in just a second, is this whole, you can't put a patient into a pharmacy that you own, because clearly they're paying their own pharmacies, the PBM owned pharmacies, more than they do an independent pharmacy, and that's not right. So I think, again, as more states are starting to become aware, and not only that, but see states like Ohio where they've had audits, and that's kicked off a lot of um, audits from the state auditor. They've been saying, well, look, what we actually contracted for with you as a PBM, we're not getting those benefits. So that's put a lot of public scrutiny on this. Kentucky, I know you asked, they passed a law. They had a lot of bills that didn't get passed this session, but they passed this one where they were trying to make so that the state would hire a single pharmacy benefit manager for all Medicaid managed care companies, and it's got to have one formulary instead of the 5 that they were using. And when you have multiple formularies, you have multiple prices, and pharmacies get manipulated with how much they get reimbursed, and that's not right either. So it's a really major step for transparency, and I applaud Kentucky for exactly what they did.
And back to the Rutledge versus PCMA case, it's now been postponed to October due to the coronavirus pandemic. In recent months, have you seen anything about this case change, or is it really just on hold because of everything going on with the pandemic?
Yeah, it's been a tough time. It's on hold definitely because of the pandemic. There's really no other nefarious reasons behind that. It's just that, it's just been pushed back because of the delays. The only thing that's really changed, and a couple of people have been asking me about this, is that, okay, you've had the Solicitor General leave. He's resigned. So what does that mean? Is that mean that we're not going to get the same argument? You're going to get the same argument. That's what the government actually has made its position on through the Solicitor General's letter to the Supreme Court. So they're going to argue, whoever comes in is going to argue that position. So I feel pretty good about that. It's just a matter of time waiting. October 6th at 10 o'clock, I'm going to be listening. I think like a lot of pharmacists with Beta Bear trying to figure out, okay, do we get clarity today? I think we do.
And lastly, what are you exactly going to be watching for and listening for during the arguments? And what should pharmacists and others be prepared for when they're tuned into this case?
I think it's a good question, number one. I think it's a two-part question. So first, anytime a lawyer watches the Supreme Court, we really try to figure out, okay, what happened beforehand? So we kind of have gotten a trend of where most states have been, which is we're going to pass something to have PBM transparency. And courts the Supreme Court really doesn't take a lot of stuff unless there's been like a movement towards something. So I'm not surprised that we're at this point, which is very encouraging. Second, you want to figure out, okay, was there something that the Supreme Court got, which to our favor, we believe that they've got the Solicitor General letter, which is good. So that's another thing. Third, you watch the justices themselves, at least listen, how they ask the questions to each side. So you can kind of gauge exactly what way they're going to lean towards. So I'll be watching that, and I encourage other pharmacists and interested stakeholders to do the same. I think while we're waiting this out, it's still imperative for pharmacy to push forward and still kind of wrap things up if you have things lingering in the legislature. I know COVID has made it very difficult because the thing that we do want to talk about is COVID. So if you can make your case that COVID actually relates to some of these pharmacy policies. So if you can make a case that COVID relates to obviously testing, you can make a case that COVID relates to making sure the pharmacy stays in business so that people have a place to fill their prescriptions. That's good. So you can also talk about MAC and audit protections and things like that and just say this is why it directly relates to COVID. I think the last thing I would suggest too is really look at your contracts during this time, because I know a lot of pharmacists are saying, okay, are there smarter ways that we can do business? Can we change wholesalers? Can we look at different third parties? Can we join, a group, a buying group? Can we do these things? Really look at your contracts to figure out exactly what you're doing, because that's the lifeblood of your business. And I think pharmacists just say, well, there's really nothing I can do about my contracts. Well, that all determines how you get paid, all of that. So take a look at that. You do have some ground to stand on, and there are people that can help you provide clarification if you don't. But those are the three things that I would do while we're waiting this major decision.
Ron, thank you so much for joining us. Now let's hear from some of our other MJH Life Sciences brands on their latest headlines.